All right, welcome to our little show here that we have.
Yeah.
And Keith, you and I were just talking about our portfolios today.
Yeah, it's not going to be pretty. Market was down big time.
It was down a lot. My son has a portfolio. He
Yeah.
started it a couple years ago and he called me today. He says, "Oh my gosh, I've never lost this much money."
Yeah, I know. It's pretty scary.
Oh,
Well, just hang in there.
yeah.
What goes down must come up. So we
Yeah.
hope.
Yeah. So what are we talking about today?
We are talking about the opposition that Blake Lively filed to Jed Wallace's motion to dismiss. So Jed Wallace wanted out of the case. And just to, I guess, give some context to it, he sued Blake Lively in Texas federal court. The thing that was interesting is that Blake Lively actually had filed a suit in Texas state court before Jed Wallace sued under a procedure that they have in Texas, Rule 202, that allows you to get pre-litigation discovery, but you have to go to court and ask the judge for permission. And so she actually filed that in January. She drops that petition, and then Jed Wallace sued her in federal court. And then Blake Lively included Jed Wallace in her amended complaint when she amends it and pulls Jed Wallace into the New York action.
I see. Okay. So then there's a 12B6 filed by Jed Wallace saying we should, he wants to dismiss the claim against him that was filed by Blake Lively. And so now Blake Lively is responding back with her team of lawyers and in opposition to Jed Wallace's 12B6.
Yeah.
Okay. And we're going to kind of attack this the same way we did the other pleading yesterday. But did you have any initial thoughts that you wanted to say as you reviewed the opposition?
I mean, overall, I think for me, it kind of fell flat, and I don't think it was a great opposition. I think that Jed Wallace has probably the better arguments, and we'll go through those and we'll explain why that is. And man, was this thing wordy. Oof. What did you think about that?
Yeah, I think the form of it was bad. I don't think it was easy to read and digest. And I think the substance, as far as its, if you were to break up its writing and make it a little bit more digestible as you're reading it, I think the substance was there. But I think you also found some real holes in the arguments that the team Blake Lively is making against Jed Wallace. And again, we have some sympathy for Jed Wallace in all this because of his declaration that he filed in this case. And the reason we put some stock in his declaration, well, let me just throw it to you. Why do we put stock in a declaration that's filed in a case which really shouldn't be used, obviously, at a 12B6? But why do we think a declaration at this point in time probably is accurate as far as Jed Wallace goes?
Because any lawyer filing that would be very careful about what you submit, because it is under penalty of perjury. It's very early in the case. Lawyers by design, we're conservative creatures. We don't want to put facts under penalty of perjury in the early stages of the case until we know darn sure that they're true or they're supported by admissible evidence. So the mere fact that he was willing to put all of that in a declaration under penalty of perjury makes you think, the lawyers must have felt pretty good about it.
And if you believe him to be accurate and truthful in that declaration, you kind of feel bad for him. It sounds like he did minimal work, according to his view of it, did minimal work on the case, I think August to November of 2024, a very short period of time, and really was just looking at stuff and reporting back on what they were seeing in social media at the time.
Yeah, that was his take under the declaration. Of course, Lively and gang are accusing him of far more nefarious activities, but
yes, that's true. So, well, let's jump right into it. So, I think you wanted to start at page 6 just to give us some context of what we're talking about here. So let's take a look at that.
Yeah, I thought it was interesting. If you look on page 6, just before heading B there's the sentence that you have highlighted. It says a few days later. So a few days later, Mr. Baldoni set the tone for the social combat he and his co-conspirators would enact, sending Miss Abel a thread on X that had accused another female celebrity of bullying women. Mr. Baldoni stated, "This is what we would need." So they're going through all the various texts between Abel and Nathan as part of their argument here. And those texts are in the First Amendment complaint. But the thing that I found interesting about this statement, this Mr. Baldoni saying, "This is what we would need," which I do remember seeing that text. It was in Exhibit A to Baldoni's complaint. That could be taken any number of ways. It wouldn't necessarily have to be taken negatively. And so he could be saying, if you put yourself in Baldoni's shoes, you could be saying, look, I was bullied by somebody. And here's an article about somebody else talking about being bullied. So this is the sort of information that I want to make sure that we share so that people understand that I was bullied. It doesn't necessarily mean, oh, we need to, this is the type of smear we need. He didn't say that. So I just thought it was interesting that they're using a statement by Baldoni that really could go either way. I don't think it's as conclusive as they're making it sound.
He certainly didn't say that he will drink the blood of his enemies here. So
Right.
he was just getting started. All right.
Yeah.
What's the next call out you want to talk about?
The next one is this information that they have about Jed Wallace. So in the complaint, they're saying that Jed Wallace is a hired gun with a proprietary formula for dealing or
Defining.
Yeah, for divining artists and trends. And then he specializes in executing confidential and untraceable campaigns on social media platforms like TikTok, Instagram, Reddit, and X to shape public perception of his clients and their adversaries, flooding the zone with their manufactured narratives. I don't know where they got that. I'm just curious, like, where does that come from exactly? Because I don't remember seeing that. We tried to find some information on Jed Wallace online. I don't remember seeing it there.
They're saying it's, obviously it's in their four corners of their document, their amended complaint at paragraph 217 and 218.
Yeah. And I looked at those. I have the complaint in front of me that Lively filed, the amended complaint. And here's what's interesting about 218. It starts with, on information and belief, Mr. Wallace specializes in,
right,
et cetera, et cetera.
Right.
So what does that tell you?
It means that they're just taking their best guess at it because they believe it to be true. And so here in a motion, obviously, they're overstating it to some extent, but it is in the complaint. And they do refer back to the paragraph in the complaint where they make these allegations. And at 12B6, at the 12B6 phase, we're stuck with accepting, and at least for the time being, that the complaint allegations are true. And then we measure them to see if they comply with the rules of pleading.
Yeah. And this goes against Jed Wallace's declaration where he says, I don't even know how to set up an untraceable campaign.
So why can't the court look at his declaration?
Because it's outside the four corners of the complaint.
Yeah. So at this level, we're not. If we were at a motion for summary judgment, we certainly could look at declarations. But here we're just at a 12B6, which is early on in litigation. We're just saying, hey, have you pleaded what you need to plead to get this case going? And of course, Mr. Wallace is saying I shouldn't be here, and that may be true, but it may not be the 12B6 timing that allows him out of the case.
Yeah, on that basis, anyway.
Right. Yeah.
So the big issue in this whole thing.
Well, let me run you through the issues. So the first issue we have here is what we call a conspiratorial personal jurisdiction. And Keith, I'll be honest with you, I did not know what conspiratorial personal jurisdiction was until about 3 hours ago. I looked it up, and you and I had a discussion about it. And again, it's conspiratorial personal jurisdiction. I know what personal jurisdiction is, and I know what conspiracy is. But I've never seen this, and I had to go and do some research, and you and I had a nice talk about it. Why don't you introduce us to this new concept, or not a new concept, new to us concept?
Yeah, it is an interesting concept, and there are some elements that you have to prove. And so the idea is, if you're part of a conspiracy, and if some actors within that conspiracy meet the requirements of personal jurisdiction, then all the conspirators should have to come in on that jurisdiction.
So just let me get that clear. So if I'm in California, I'm in Texas, and you're in New York, and you and I conspire to rob a bank in New York, and we talk about it, we plan it. I stay in Texas the whole time, but you go and you rob the bank with my instructions. Is that something that gives me minimum contacts now with New York?
Possibly. So it's not an easy question to answer, but that would be the basis of where you would say, okay, but you're part of this conspiracy, so now you have to come to New York. They have jurisdiction.
Let me take it one step further. I say, hey, Keith, let's smear somebody. Let's call them an S predator, and let's go after them. And you're in New York, and I'm in Texas, and I tell you how you do it all in New York. You go ahead and you go smear that person. Are we now in a conspiracy to smear somebody? And does that give New York personal jurisdiction over me, a Texas resident?
It's a definite maybe. So these are not easy questions to answer, but arguably, yeah, if you're part of the conspiracy, then the answer would be yes. But the question still comes down to, does the court have the right to exercise jurisdiction over you? And that's a really interesting question.
And what do we see here at page 10? Let's take a look at that. And where do you want me to call out there?
It's the first paragraph after...
it's the argument?
Yeah, under I there. There you go.
That up.
By the way, Jordan wants to know, do you know who drafted this one, guys?
Yes, it was not Ezra Hudson. It doesn't look like it was Mr. Schuster.
Yeah.
And it kind of surprised me because we'll go into it a little bit later, but in my mind, this was not very good drafting.
Wasn't the best. Yeah. And we'll show some examples of that. But so here's the standard right here. So the three elements you have to have is that a conspiracy existed, that the Wallace parties participated in the conspiracy, and that a co-conspirator's overt acts in furtherance of the conspiracy had sufficient contacts with New York.
So this is a bunch of black letter law, Keith.
Yeah.
Talk to us about Jed Wallace in Texas. Talk to us about the parties in this case. What is it that Blake Lively's, what's her argument here? What's she trying to say?
It all comes down to minimum contacts. And what we call that is the long arm statutes, the long arm of the law. And so the question becomes, can New York exercise jurisdiction
Over Jed Wallace.
over Jed Wallace? So can New York federal court exercise jurisdiction over Jed Wallace in Texas under the long arm statute? So what's the long arm statute? What does that require? So for everybody living in the United States, if you live in one state, you cannot be sued in a different state unless that state has personal jurisdiction over you.
And how does the state get personal jurisdiction over somebody?
You have to have minimum contacts
Oh
with
my
that
gosh.
state. Yeah, this is getting
Alright.
very gray area.
So what are minimum contacts with that state mean?
So by and large, it's where a person, so if you purposefully avail yourself of the privileges of the other state, you conduct business there, you live there, you invoke benefits there by contracting with people there.
Like go on vacation there?
No,
Okay.
just going on vacation is not enough. And
Okay.
that's one of the examples I wanted to give. So you're a California resident. Let's say you go on vacation in New York and you get into a car accident and you were negligent. But the next day your plane leaves, you come back to California. Your only connection to New York is that you vacationed there for a week, got in a car accident and left. Can you be sued in New York?
I don't know. What's the answer?
You cannot, unless you have other types of contacts. Just going there one time on vacation is not going to be enough to establish minimum contacts. That means the plaintiff has to sue you in California, which is a state where the courts do have personal jurisdiction over you. And of course, a New York plaintiff may not want to sue you in California state court, so they have the option of suing you in California federal court under diversity jurisdiction, as we talked about before. But if you don't have these minimum contacts with another state, you cannot be sued in that state. So the question becomes, what contacts does Jed Wallace have with New York? Has he done business there?
No.
Does he live there?
No.
Has he contracted with people there to do business there?
Apparently not.
Has he availed himself of the benefits of New York law by filing suit in some other manner?
Not that we're aware of.
So if without those minimum contacts, then there's no personal jurisdictions. There's no ability to exercise the long arm of the law and bring him to New York.
So then when Blake Lively comes up with this creative idea that she's going to have conspiratorial personal jurisdiction, is that different than a long arm statute reaching out and pulling somebody into the state?
So that's where the argument is, and it's a very interesting argument. Lively would tell you yes. Lively's lawyers are saying that by the mere fact that you're part of a conspiracy is enough for us to drag you into New York, even though you otherwise would not fit under the long arm statute.
Is the reason for that is because there were people in New York that were part of the conspiracy while you were in Texas and you were talking to those people?
That's the argument.
Okay.
Yeah, and we'll talk a little bit about why I think that's a little bit of a thin argument, but that's the argument.
Okay.
Now, I went back and I looked at Jed Wallace's motion to dismiss, and he quotes a really interesting case. And it's a case that says that federal courts have been increasingly reluctant to extend this theory of jurisdiction, meaning conspiracy jurisdiction, beyond the context of New York's long arm statute. So in other words, federal courts are reluctant to allow jurisdiction to be more broad under conspiracy than it would be under the long arm statute. So if you don't meet it under the long arm statute, then why should you have this huge loophole in the rules and allow us to drag you to New York just because you were allegedly part of a conspiracy?
So what I hear you saying is that federal courts, and specifically this New York federal court, they're reluctant to use conspiratorial personal jurisdiction over somebody if you couldn't also get them by the long arm statute.
Right.
And
Right.
that means they have to have some type of minimum contacts with New York.
Yeah, some contact there that would make sense. And this is all of a function of fairness. So courts are thinking, what's fair? It's not fair to drag a defendant into some other state
Because you should never been to.
that you have no contacts with. Now, it's fine for the plaintiff because the plaintiff's the one who is voluntarily availing themselves of the court system. They're choosing what court to go to. But defendants aren't. They're in this, reluctantly or involuntarily. And so it's not fair to drag them to other states. So that's why the long arm statute rule even exists in the first place. So what Lively is arguing is that, well, the only argument that Jed Wallace made is that there was no conspiracy. We didn't engage in a conspiracy. And they're kind of right. That actually is the main argument in Jed Wallace's motion. But I think that there's another argument that they do reference that I just told you about, this case law that says courts are reluctant to exercise that kind of jurisdiction. And I wish that Jed Wallace would have made that argument a little bit more front and center.
What is that argument?
The argument is the federal courts are reluctant and therefore should not exercise jurisdiction beyond what the long arm statute provides. So let's not create this big old loophole that lets you drag people all over the country because you allege a conspiracy. Let's see if they meet the long arm statute. And if they do, fine, they can go to New York. If they don't, then go to Texas, sue them there.
Yeah, think of how unfair it would be to be able to use conspiratorial personal jurisdiction as a final grab to force somebody to come a long way to a court, way that they've never been to the state, they've never availed themselves to the state, and you're forcing them to come based on an allegation you're making in a complaint, which has to be accepted as true at the 12B6 phase.
Yeah.
And so you're basically really opening up jurisdiction more than the federal court's comfortable with.
Yeah, it's huge. And I just told you that if you went to New York and got into a car accident and were negligent, but your only connection to New York is you vacation there for a week, you can't be sued in New York. How is this any different? I mean, this is almost worse because they didn't even go to New York to get in the car accident. They never touched foot in New York. So it seems to me that Jed Wallace has the better side of this argument.
So as far as conspiratorial personal jurisdiction, again, we're about 3.5 hours now into that term. What is your feelings on what potentially Judge Lyman's options are in responding to this argument?
If I were the judge, I would say, let's just stick to the long arm statute. If you don't meet the requirements of the long arm statute, then I'm going to slice off this part of the case and send it to Texas. And here's the good news. You guys are already in Texas federal court. So, hey, no problem. Let's just make it part of that.
So this is one of those moments where a judge is going to be able to make a decision at a 12B6 phase because this is a legal determination, and that is whether there's minimum contacts with Jed Wallace and whether the court's going to pull him into the case. Now, keeping in mind that the court does have to accept the allegations that Blake Lively has made as true, and that is that there's this grand conspiracy that's going on. But the court can be reluctant based on federal standards and say, I'm not going to pull some guy from Texas that I don't think has minimum contacts with New York.
Yeah. Now, the alternative is the court could say, let's just leave everybody in the case. We'll get past this motion to dismiss, and we can figure all this out later. I can always send it to Texas before it goes to trial. I think that that's a more severe option, but the judge could do that.
Yeah.
So, I mean, which one would you do if you were the judge?
I feel sympathy. My personal view is I feel sympathy for Jed Wallace on what I know thus far. And if maybe there's something else in the evidence I'm not aware of, I feel that he's been dragged into this. I think he's trying to run a business in Texas, and he's going to have to go to New York and be dragged to New York. If they get him up there, it's going to make his life miserable. And so this is a way for the judge to say, no, I'm not going to do this to this guy. You guys go fight it out in Texas and see how the case goes down there.
So that's a really good example of how that declaration may actually do some good.
Even though the judge isn't supposed to consider it.
But you can't unring the bell, as they say.
Yes.
So you've read it and you're like, I feel kind of bad for this guy.
Yeah. Eric, did we miss a question?
Well, no, first, this was a good comment by JT. They say in reference to Jed Wallace, he appeared to just be monitoring the situation. And I'm wondering why Blake Lively thinks he was running an undetectable campaign, but yet she knows. If it was untraceable, then how would she know?
Yeah.
Nobody knew about it, and he's the expert.
He was really bad at it.
And
he could run untraceable campaigns. He's just not good at it.
They're using those things like his, LinkedIn headline that says hired gun in quotes. And I was saying, I think it was last week, it's like when someone is hiring for a position, they're like, oh, we need a rock star to be someone to work at Chase Bank or something like that. So, and Terry also wanted to know, can you remind me of how this thing got out of California state court into federal court? These proceedings are moving much faster than state court.
Yes, and they will go faster in federal court.
Yep.
Keith, there's been a lot of questions and a lot of confusion, and I almost wonder if it's going to be beyond the scope of what we're covering today. But do you have a nutshell answer as to why it is that we had a CRD complaint filed in California by Blake Lively, and now we're in New York federal court? Can you just give us the cliff notes?
First of all, plaintiffs get to choose their forum. So we're in New York federal court because that's where Blake Lively filed, and she gets to choose. The first plaintiff who files oftentimes wins on venue because they get to choose. And then the question is, was there jurisdiction over Baldoni and the Wayfair parties in New York? They haven't objected to it. And so they're accepting that jurisdiction. And so there you have it. That's why it's in New York federal court.
Okay. And as far as the EEOC, whether there was a right to sue letter or not, we probably don't know, right?
We do not know if there was or was not.
And so there are 2 Title VII claims that are included in Blake Lively's civil complaint, but she also has a half dozen or more California-based claims under the FEHA. So it seems like she's covered one way or the other, even if she didn't do an EEOC, if she didn't exhaust her administrative remedies with the EEOC.
Yeah, so if she did not get a right to sue under EEOC, even if those 2 claims go away, she still has all the FEHA claims under California law that can be tried in New York federal court.
Okay, so we've gotten through conspiratorial personal jurisdiction. Let's move on to the arguments regarding venue and transfer. That starts at page 13 of the opposition. And what did you want to share with us there?
Yeah, on page 13, really the whole idea, because they're arguing that venue is not proper here, and it's the paragraph that starts with, okay, wait, let's stop. Before I even go into this, look at that paragraph that starts with here.
Mm-hmm.
Okay, you're talking about a paragraph that takes up almost an entire page.
Mm-hmm.
I mean, that's, to quote Churchill, this paragraph, by its very length, defends itself from the risk of being read.
Mm.
I mean, that's part of the problem with this brief is that, man, that's almost impenetrable.
By the way, to interrupt, the names sound very similar, but this must be Michael Gottlieb, and Mitchell Schuster is on Baldoni's side.
Oh,
very
similar. It is Gottlieb. You're correct. I stand corrected. Yep.
Roman.
Thank you, Roman, and thank you for showing up to all of our shows. We appreciate your support. Yeah, it is Gottlieb that drafted this.
So, what do you think about this paragraph, Stuart?
It's terrible. And, people just look at this. It's overwhelming to read this. First of all, it's full justification, which means it goes all the way from the left, all the way to the right, and it's just a bar going down. It's hard for your eye to go from the left and the right over and over again with full justification. People do it because they can get a little bit more into the brief without exceeding the page limit. And also, you can't have a paragraph this big. If you're a judge or a clerk that has to review this, you're literally not going to read this.
No.
You're simply just going to throw it to the side because you have so many cases you're working on. And so you have to be able to, look, all of this could be very substantive. All of this could be very good information. It's just presented in a way, in my opinion, I think it could be presented much better. And so here, you're just overwhelming the people that are supposed to read this. And the problem with this particular opposition is, you see this over and over again here. The paragraphs are monstrously large, and it's just like I don't even want to read it. I'm not even like most things that I want to read. It's exciting. This I go, oh, I don't even want to read it.
Yeah, I mean, and you're the master of form for our firm. I mean, you are always looking at what makes a brief look fantastic and make people want to read it. And I agree, full justification is terrible. It's kind of a funny thing to complain about, but.
Can I jump in here real quickly just to show a couple examples?
Yeah, I wanted to see if you had some ideas of what this could look like.
All right, so I'm going to show the jury pool. This was on page 8. I literally took this right out of their opposition, and this is the paragraph they have, and it starts on August 10th. And I probably can blow it up just to show how this is just a paragraph. Okay, there it is. So there's the paragraph, and you can see they do use some italics with some bolding to really get their point across. And I think they have to do that because they don't want to lose the point they're trying to make in this word salad here. This is a giant word salad.
Right.
We're not sure what we should be reading. There's paragraph signs, there's numbers, there's capitals, there's block text is fully justified. This is really hard to take in. And by the way, I would say this about any lawyer's writing. I'm not picking on Blake Lively's lawyers. I just think that this is not the way to do it. So, Keith, I have nothing better to do with my time during the day. So I actually redrafted this paragraph
Okay.
to show our jury pool what good writing, and I apologize, I only had an hour to do this, so I may not have good writing, but what I think good writing should
they'll
be.
be the judge of that.
They'll be the
Yeah,
judge of that.
let's
That's
see.
right. So here's the paragraph again. This is what it looks like before, page 8. You guys can go to page 8 and take a look. And here's what I did. So first of all, I just want you to see, I took the full justification away. And so you can see, let me turn my laser pointer on here. You can see on the edges here how it's easy for your eye to go from his all the way over to team's effort, and you keep going. So you've got this breakup over here. It's important to see that breakup because it just makes it's friendly to your eye as you're reading. The other thing is I actually used paragraphs.
Yeah.
So it's not just one big block.
Yeah. You gave us hors d'oeuvres.
I gave hors d'oeuvres because it's easy to eat hors d'oeuvres. So let's look at each one of these hors d'oeuvres. On August 10, TAG expressly acknowledged the success of the Wallace party's efforts to redirect attention away from Mr. Baldoni's misconduct and toward a manufactured narrative targeting Miss Lively. Now, I'll be honest with you, that's a little longer sentence than I normally like to write, but at least it's in an hors d'oeuvre that is easy, and there's a lot of white space around it, so you can read it. Then, well, what's this whole TAG thing about? Well, that's the next paragraph. TAG stated that they had started to see a shift on social due largely to Jed and his team's efforts to shift the narrative towards shining a spotlight on Blake and Ryan. And then you go ahead and do a cite to the amended complaint, paragraph 245. Following this shift, oh, look at that, an introductory sentence in a paragraph that bridges the former paragraph with this paragraph.
Yeah.
So now the reader knows where we're going.
Right.
Following this shift, Miss Nathan texted, the majority of socials are so pro-Justin, I don't even agree with half of them, LOL. And again, they cite to the amended complaint. She later bragged, this went so well, it was genius. Now, that's the end of that thought. We're going to go on to another thought. Over the following days, Mr. Wallace and Street Relations led a digital team working with Miss Nathan, Miss Abel, and TAG. I could keep reading this, Keith. I'm not going to bore everybody. The point is, look at this, and I'm going to do a quick back and forth here. Let me get out of the call out here. So this is what I wrote, just pulling the thoughts together. It's the way I saw them. And then here is what the other person wrote.
Big difference. It's funny because just the taking away the full justification is a huge difference. And then breaking it up so that you can actually digest each piece of it, it makes a big difference. And, you know, the opposition we were looking at yesterday that Baldoni filed against Ryan Reynolds, it was not full justified. They did it like you did here, which is way better.
Just left justification.
Yeah.
Let me just show one more real quick, Keith. This came from page 11 on the brief. And again, I'll call this out. I won't read it. You can go read it for yourself if you're interested. But just look at this giant of a paragraph. Look at that full justification. I'm not sure what's important there. I'm not sure what I'm supposed to read. It just is overwhelming to me as a reader. And then let's look at what I did. All right. So you can see here. Let me just show the back and forth again, the difference. That's what they had. Here's what I did. And again, I'm just, you know, I may not be the perfect drafter in 1 hour, but in 1 hour, I was able to really clarify and hit the themes and what they were trying to point out and made it appetizing for a judge or a clerk to look at
and read it
read it and understand the arguments that I'm making.
Yeah. Yeah. It's a big difference. And that's really where we, you know, really appreciate and enjoy good writing. And,
but I digress. So where were we on this large paragraph here?
Page 13 up at the top. So where it says here, a substantial part of the events giving rise to, so, okay, there you go. Go ahead and munch on that word salad. Here's the point they're trying to make on venue. They're trying to say,
who's they?
Lively is trying to say that a substantial part of the events giving rise to the underlying tort, which is false light, intentional infliction of emotional distress, and all that, took place in New York. But then they quote the reasons why they think that's true. So they're saying that the amended complaint alleges that there was an all-hands meeting at which Miss Lively and others discussed Mr. Baldoni and Mr. Heath's misconduct. So that was the 17 points that they went over. That was in 2023.
Was Jed Wallace even on the scene?
No, he was not until August of 24 was he on the scene. Also, Mr. Baldoni and Mr. Heath, as officers of Wayfarer, engaged with Jones Works, who has a company in New York. Well, I don't know if just engaging in one Jones Work, I don't know if that'd be enough even for Wayfarer to have minimum contacts with New York, because Jones Work also had an office in California,
Los Angeles. Yeah.
But how does that affect Jed Wallace? I don't understand the minimum contacts there. And then Miss Sarah Nathan continued to correspond with Miss Abel and Miss Nathan, even exchanging drafts of a story pushing the Wayfair party's narrative about Miss Lively's role in editing the film. I'm confused. How does that have anything to do with Jed Wallace? So they're saying that there are minimum contacts in terms of the actions of taking place in New York, but then the things that they're citing to, it just seems very weak. It seems very thin to me. I don't get it. I don't see it.
So ultimately, do you have anything else you want to share with us on venue?
No, I mean, I think that kind of tells the story. And so I think that Jed Wallace has the better side of the argument, it seems to me, on venue.
And for our jury pool, is there just a quick primer you can give on the distinction between jurisdiction versus venue?
Jurisdiction is the right of a court to bring you into court. So when a court has personal jurisdiction over you, you then have to participate in that legal process, and the court has a right to even issue orders and ultimately a judgment against you.
Because you've availed yourself of the state, therefore the courts have control over you. Okay.
Yeah. Venue is not whether or not the court has jurisdiction, but where's the best place to have this? So for example, in California State Court, the state of California has jurisdiction over you because you're a California resident. But is venue proper in San Diego County or Los Angeles County or San Francisco County? Well, that depends. It depends on where the action took place. It depends on the convenience of the parties. There's a number of different factors that go into that. But just because venue may not be proper in San Francisco court could exercise jurisdiction over you because you're a California resident.
Okay. Thanks for that clarification. And then we're going to get to failure to state a claim. And Keith, really, there's this false light issue. I don't know if you really want to go into that. I know that you wanted to get into the FEHA stuff. What are your thoughts?
Yeah, the FEHA was kind of interesting. Let me take a look at my notes here.
And I think that's page 20.
Do you want to, this was a question from Chelsea Smith. Thanks for this. This was before we even started, but she asked, can you please explain how they seem to flip-flop and first argue the false light should be under New York law, but then the next part they are arguing that it should be California law. It's confusing.
It is confusing. And I think that you're hearing a lot of different things on this false light claim, especially because you're hearing New York, California, Texas. It reminds me of a Wheel of Fortune of state laws. Like just spin the wheel and we'll see which one we're going to go with. But on the false light claim, Jed Wallace was saying that the case should be in Texas because that really is where the false light claim, the law of false light is going to apply as Texas law. I think Lively argues, well, you can apply Texas law in New York federal court. That's a true statement. But then she also argues about how there's pretty much everything happened in California, so we should apply California law. I don't think, in terms of what law you're going to apply, I don't think that helps you get out of New York court. And we've seen that already with the other arguments. New York court can apply California law, Texas law, New York law, whatever they want to do. But in terms of this back and forth on these choice of law arguments, especially with the false light one, it was confusing to me too, because it seems like everybody's kind of pointing in that direction, trying to figure out what law we want to apply. And really what they're doing is they're using the law or the arguments that best favor them in that moment.
Of course. Yeah. All right. So this is a, what do they call it? A cafeteria plan for law and which one applies. All right. So we're talking about the FEHA, and Keith, you came up with a really interesting comment off of looking at a couple California cases dealing with the FEHA. And I don't know how you want to first address this.
Let's start on page 20, and it's the first paragraph after B.
Okay.
So this is the argument. So the claim against Jed Wallace is that he aided and abetted in violating FEHA, which you can do. So a non-employer can actually be liable under FEHA if they aid and abet somebody else, an employer, in harassing somebody. So they're saying here that first, that Ms. Lively has not adequately alleged the knowledge element of the claim and against Jed Wallace. And second, that all of the relevant primary conduct occurred prior to the Wallace party's aiding and abetting began, which does seem to be true.
And both of those arguments, according to Blake Lively, are meritless.
Yes.
Okay.
Yeah. So now let's go back to page 21, and I'll show you kind of the crux of her argument here in the first paragraph. Oh, that's not helping, is it? So about midway down for the first paragraph, it says the law does not require that the Wallace parties knew that the FEHA existed or Googled it or fired up Westlaw asked ChatGPT whether it was unlawful to retaliate against someone for speaking up about harassment at work in order to be liable for aiding and abetting. Well, let's just test that theory. So I actually found this case, and it was cited by Jed Wallace in his case, in his motion to dismiss, and it's called Smith versus BP Lubricants or Lubrications. And let me give you the cite to it if I have it here. It's actually a California Court of Appeal decision, and it's 64 Calap 5th 138. So
What year is that, Keith?
So for the lawyers out there, you can look that up. It's 2021 opinion, 64 Calap 5th 138. And it talks about, can you be liable for aiding and abetting? But there's a number of things that you have to, there's some elements. So and let me pull out the elements here. So first of all, there is an aiding and abetting workplace discrimination. That is a real thing under our California government's code. You can be held liable for that. But here's the elements. So first, the person who's doing it, so Jed Wallace, well, first of all, the employer. So you'd have to say first, the Wayfarer subjected Lively to discrimination or harassment. That's the first element. The second element is Jed Wallace knew that the conduct violated FEHA.
Okay, I want to be clear on this. So Jed Wallace in Texas would have to know whatever conduct he was conspiring about. He would have to know that it took place. He would have to understand what FEHA was.
And that it violated FEHA to do that.
Okay.
So, because you can't know that you're violating FEHA if you don't know what FEHA is.
You have to, by definition, have to know what FEHA is.
Yeah.
Okay.
And then you have to show that Jed Wallace gave the Wayfarer parties substantial assistance or encouragement to violate FEHA. So the claim here is that the way that he aided and abetted is by helping out with the smear campaign, which was a violation of FEHA, according to Lively. So that's the argument that Lively's laying out.
That's the easier one to allege.
Yeah.
And then?
So then with Jed Wallace, they're saying, and you aided and abetted it, and you didn't have to know. So they're saying that you didn't have to know.
Who's they? Just so we're clear.
Yeah, sorry. Lively is saying that Jed Wallace didn't have to know whether it was unlawful to retaliate against someone.
And what does California law say about that?
You do have to know, because you have to know that the conduct violated FEHA. And so you have to know what FEHA is to know if the conduct violated it.
So Jed Wallace had to know what FEHA was, and he had to know there was a violation of FEHA. And what Blake Lively's team is arguing is, no, he doesn't have to be aware of those things.
Yeah, he doesn't have to know that it's a violation of FEHA. He just has to know what conduct he engaged in.
So Brian Freeman, if you're listening.
Yeah,
that's our free tip for the day.
That's the argument. Well, in Jed Wallace's counsel. So yeah, the argument is that it's.
I'm sorry. I didn't realize. I am confusing my lawyers here. Who is Jed Wallace's lawyer? Does the jury pool? Anybody in the jury pool? Eric,
I have it on the brief here.
Who is the attorney for Jed Wallace?
I'll do some sleuthing.
I got it right here. It's Charles Babcock
out of Texas. I'm
and
assuming.
Joel Glover at Jackson Walker, and they're out of Houston, Texas.
Houston, Texas. Okay, all right. Give them a shout out.
So they did a good job in terms of finding that case and quoting that case in their motion to dismiss. I think the argument here that Lively's making to try and get around it, it falls flat, because you do have to understand, and it makes sense too. If you're aiding and abetting in a violation of FEHA, I have to know that I'm doing that. How would I know that I'm doing that if I didn't know what FEHA was?
Right. Although if you were to, some California legislature, some of the people up there in the legislature may want to pass a law now that makes you liable even if you don't know, because it's not a bad idea.
I wouldn't put it past them.
Okay. All right. So then we get into this. I think you also found some issues with the intentional infliction of emotional distress, the IIED claim, and that's on page 22 of the opposition. Let me get there, and then we can pull that up and you can walk us through it.
Yeah, I actually want you to go to page 20. Let's start at 24.
24. All right, I'm there.
So this is an interesting claim. So intentional infliction of emotional distress.
And where do you want me to call out, Keith?
It's the very bottom paragraph that starts with the Wallace parties cannot credibly argue. There we go. The Wallace parties cannot credibly argue that their conduct was not extreme and outrageous. The primary argument for this proposition is that it is hard to imagine how a public relations point-counterpoint could be a cognizable IIED claim. So what Wallace is arguing is, how is it outrageous that we're just doing point counterpoint in terms of public relations? Is that outrageous behavior? It doesn't seem like it. But what Lively is arguing in return is, well, but it could be, because if your conduct, and this is page 25, and it's going to be, I guess, the top paragraph there. And it's about near the bottom of that paragraph where it cites this case called Ty versus Runyon. It says, extensive and virulent posting of comments on various internet forums exceeded the bounds of that tolerated in a civilized society. So that sounded pretty bad to me.
Let me get this clear. So Ty v. Runyon, we lawyers, we quote to case law because we want the judge or the law clerk who works for the judge to be impressed with the cases we quote. One of the things we need to be in quoting these cases is we need to be credible, right, Keith?
Yes, which means they need to be accurate.
Why do we need to be credible when we're giving case law to a judge?
Because when the judge goes and looks at the cases for themselves and sees that it's not accurate, then they're going to assume that your other case sites are also not accurate.
So then Blake Lively's lawyers say the Wallace party's actions here fall squarely within the outrageous conduct recognized by California courts that give rise to an IIED claim. We have a different cause of action in probate court. That's why we're having some problems saying that. And then see Ty versus Runyon. And then they even give us a little teaser of what Ty versus Runyon stands for. And they say extensive and virulent posting of comments on various internet forums exceeded the bounds of that tolerated in a civilized society. Keith, you went to Ty versus Runyon and you read the case for yourself. Tell us what you found.
So first of all, and this I think clarifies a lot in my mind. So Ty versus Runyon says that in order to bring this type of claim, the outrageous conduct that we're talking about must be so extreme as to exceed all bounds of that usually tolerated in a civilized society.
Okay.
So it has to exceed all bounds.
All right.
Right. And then this case had to do with some pretty outrageous comments.
When you say this case, Ty versus Runyon.
Yeah. Sorry. Ty versus Runyon had to do with some pretty outrageous comments that a defendant made online about a plaintiff. And they were just over the top, defamation. And they didn't even argue that they weren't defamatory. They just argued that there was no damages. And so the court looked at that and says, well, an average member of the community may find that the extensive and virulent nature of this conduct exceeded the bounds of that tolerated in a civilized society. So in other words, this court held that they allowed the claim to go through on a motion to dismiss, but all they said is, well, the jury may find that was beyond the bounds, but you'll see the quote here is that they said that the court said that the posting exceeded the bounds of that tolerated. I don't see that the court said that. I don't see that the court said that it did in fact exceeded the bounds, because that makes it sound like it's a definite, as if the court said this type of posting is automatically outrageous. That's not what the court said. What the court said was, it could be, it's possible that a jury might find that. Let's let it through to the jury. So I just thought that was an interesting distinction about what they said in their quote versus what the case actually said. I think they overstated it.
So this is the first one. This is the first filing we've come across where you and I have seen, we're not really all that impressed with it. Maybe we're wrong in the way we're viewing it. We think it could have been formatted better and presented better. Maybe they were in a hurry and they wanted to file it, or maybe it's beautiful and we just don't know what we're talking about. But what this comes down to substantively is the conspiratorial personal jurisdiction. It sounds like federal courts are a little iffy if they're going to give somebody relief on that doctrine. Is that right?
I think so. And I think the other problem is, I think Jed Wallace had some pretty good arguments, and I think it's hard to argue against those, especially on jurisdiction. And I think this idea of, well, we have jurisdiction because of conspiracy, that's a tough argument. And I think it's a very thin argument. And I think they kind of know that. And so they put as much as they could together in this opposition, but I'm not convinced.
Well, as we know, it's hard to make predictions, especially about the future. And so what do you think the judge is going to do. Judge Lyman's going to look at this, and again, it's hard for you to call this because we're not inside the judge's mind. There's so many ways that he can go on this. But what if let me make it easier for you. If you were the judge, how would you view this?
I think I would send the Jed Wallace part of this back to Texas. And I've got to be honest, in reading his declaration, it did kind of persuade me too, in my mind, that it sounds like the guy's really being put under a lot for probably not doing much. Let's not put him under too much stress here. Let's let him litigate this in Texas, because that's going to be easier for him, easier for, everything that he's going through. And that's an example of where that declaration may have done some good, even though the judge technically isn't supposed to consider it within the four corners of the document.
Yeah, I think judges, we've talked about this. I think judges are people, and I think they like to make decisions that make themselves feel good at the same time.
Yeah.
I do know that judges have to make decisions they disagree with from time to time, and they'll do it because that's what their job is. But judges like to feel good about a decision. And so if they can make a decision that falls squarely within the law and applies it to the facts of that case, and they can feel good about it, I think they're going to do it. And I think if Judge Lyman is putting his finger in the air and looking at this one, you got to have a little sympathy for Wallace based on what has been said. Of course, you can't come out and say, yeah, I'm considering extrinsic evidence at the 12B6 phase. But you do feel bad for this guy in this whole cast of characters that's fighting each other.
Yeah, I think that's right. Now, the judge could look at this and say, well, I think it's more efficient if we just keep everybody in one action here in New York. And, I don't want to harm Jed Wallace, but on the other hand, I think it's just going to make everything easier to move forward, to keep it all together. The judge could view it that way too.
And if the judge had to make that hard call, could the judge say, I'm going to have Mr. Wallace appear by Zoom, and if you guys want to take his depositions, you have to go to Texas to do that? I mean, there's also things like that the court could do to give some sympathy to somebody that may be having a financial hardship.
Yeah, that's a good point. Yeah, totally.
Yeah. All right, Eric, do we have any good questions for today?
We got a few great questions here. This is a member of our jury pool. Users Love is Kind. They say, we see so many mess ups, screw ups in the lawyers from Blake and Ryan's side, but not Baldoni's side. Could it be Blake and Ryan interfering, or are their lawyers this bad?
I honestly don't think that any of the lawyers are bad in this case. I know there was some reports in the press yesterday, Keith, or day before, where they're saying some insider is saying that Blake Lively's lawyers hate her and hate Ryan Reynolds. They don't want to represent him and they hate their lives. I don't have any insight into that. I will say that the lawyers appear to be doing very good work for the most part. I mean, this is the first pleading that we've come across by either side where we're kind of like, ooh, it could have been a little better. I mean, it's probably good enough to get its work done, and I think the judge will be able to make a determination based on it, hopefully in Mr. Wallace's favor, in my selfish personal feelings on that. But I just don't think the lawyers here are doing bad work. And it leads me to the comment that you and I have talked about with Brian Friedman. We think Brian Friedman is a fantastic lawyer, and we like Brian Friedman. We have nothing bad to say about him. But, he's like any other lawyer. He's working hard on this case. I don't think he's a master manipulator behind the scenes saying, well, they're going to do this, and then I'm going to do this, and then they're going to do this. And he's got it all mapped out. I think he's doing what good lawyers do. Every time an issue comes up, he thoroughly reviews it. He educates himself on it. He understands what the arguments are. And then he's a very skilled orator. He can go and talk to a judge. He can talk to the other side about it. But he's not all-seeing. Guys, as much as you like Brian Friedman, he's not God. He's not everywhere at once and has all understanding. He's a very good lawyer. He's an outstanding lawyer. And there's also some outstanding lawyers on the other side. So I think that who would I rather represent in this? Of course, I'd rather represent Baldoni based upon the facts I've seen. Because when you have good facts on your side, it's easier to represent your client.
And not only good facts, but I think you probably have an easier client to deal with. I think probably Ryan Reynolds and Blake Lively would be difficult to deal with, especially in a lot. And I think when you looked at the motion to dismiss that Ryan Reynolds filed, it does appear as though, I don't know if he had a hand in it, but it seems like it, just because it really was a punch in the face in a way that was not legally required or even sufficient or even, appropriate. So legally speaking, it went way beyond what you needed to do. And so you had a little bit of sense of that. I think on this one, part of the problem is Jed Wallace has the better arguments. And so this is just a tough one to argue no matter who you are. And so they didn't do themselves any favor by making the brief look like it did. And, some people, they are strong believers in full justifications. I don't know why, but they are. And so they haven't gone through the Stuart Albertson School of Proper Form, which would do them a lot of good if they did. But, for whatever reason, that's the case. It seems like Brian Friedman, though, he seems more impassioned in his representation of his client than we've seen of any lawyers on the Lively side. So I don't know if that's just because that's the type of person Brian Friedman is, or if he just has a great relationship with his client, which always helps. When you have a great relationship with your client, you feel really good about going out there and fighting hard for them. Whereas when a client is difficult, it's, you still go out there and fight hard for them, but you just don't have, it's hard to get the same motivation and zeal.
If it's true that Ryan Reynolds is yelling at his lawyers, I'm not saying that's happening, but if he's yelling and he's giving them a tough time, that's never fun to be the lawyer representing that client. No. If you have a client that's kind and generous, and Ryan Reynolds may be kind and generous to his lawyers, then it's much easier to represent that person, no doubt.
Yeah.
By the way, when you were talking, I had to laugh when you're talking about all the formatting and the syntax and everything. It reminds me of American Psycho with Christian Bale, and they're looking at everyone's white business cards, and they all look the same. He's like, "Ooh, the subtle off-white coloring and the line thickness of this font."
Yes. Are you calling Stuart a psycho?
No. Here, I like this question. Someone says, if Keith and Stewart were attorneys in this case, would they have their eyes and ears on shows like this to see how their filings are viewed by other attorneys?
Interesting. Would you?
Well, what do you think?
I would. I definitely would. Yeah, I'd be interested just to see. Well, number one, I'd want to know just how the public is perceiving things. That's important. And then I'd want to know just how it looks from an objective standpoint. So sure, I think I would.
I think it's part of your job as a lawyer to look and hear. Now, obviously, some of the people are saying some wild and outlandish things, and I don't have anything against any content creators that are pushing the envelope here and saying stuff. I mean, the audience can be the best judge of whether somebody's credible or not in what they're saying. But yeah, no, I think the 47.1 issue for certain, I'd want to know what are other lawyers saying about this, whether it's us or anyone else, because that's an issue that we're going to see tomorrow in a filing and be able to go over. And I'm really looking forward to seeing what the response is by Justin Baldoni and Brian Friedman and their crew to Blake Lively's 47.1 arguments. I think that, to me, is the Achilles heel in the case right now. So I'm dying to find out, hey, are you guys saying, let's just amend, and we're going to talk about whether she was reasonable in doing this and whether there was actual malice, because those would be the two things you'd have to bring up. So we'll know more about that tomorrow.
Yeah, I'd love to see their argument.
Tigesty, thanks for this question. A2L team, do we know how far back in time Baldoni can subpoena docs? Does it have the same time restrictions as Lively's, around August 2024 to CRD filing date, or is it from the date she accepted to start and it ends with us?
And so I guess the question there, Keith, is how far back would a court let somebody get documents in this case? And it seems to me it depends on what category of documents you're asking for.
And what claims you brought. So part of the reason why the court limited Lively's claims is because the judge looked at her complaint and said, it looks like your complaint starts with facts in August of 2024. So let's not go beyond that right now.
Let's start there.
Let's start there. That doesn't mean the judge wouldn't allow it at some future date, but for now, that's where we're going to start. It seems to me that the defamation claims that Baldoni brought do go back to
2023 at least.
Yeah, because of the 17 points. So
Yeah.
I would think a judge would allow him to subpoena docs at least back to 2023.
Yeah.
And what you do is you start there, you get your evidence, you see what's out there, and then you use the information you obtain as justification to go back further if you need to.
That's right.
I think this was a genuine question, but just wondering why you guys had so much sympathy for Jed Wallace. We kind of talked about that, but any more?
Well, I just think that if his declaration, if you read his declaration, the infinite timeline, we'll attach it to underneath the description of this video so people can take a look at it for themselves. I just have sympathy for the guy. It seems like he got caught up in doing a little bit of reporting on social media, and he's swearing under penalty of perjury that that's all he did. Now, think if he lies in his declaration about that, he will be torn apart in deposition and torn apart at trial. Remember, we hear from witnesses 3 times in a case publicly. Well, not publicly, but sometimes publicly. But we hear from them 3 times. Let's see if I get all my exceptions out of the way first. But we hear from them in declarations when those are many times filed with the court. Sometimes they're not. Sometimes they're just shared with the other side privately. We hear about from witnesses in deposition, and that's sworn testimony that they have to tell the truth. We may not be able to see those in this case right away. and then we hear from them at trial.
Yeah.
Not everybody has to do a declaration, and that's something
Right.
you can choose to do in most cases. Sometimes you're required to get over a motion for summary judgment or something, but for the most part, you're going to have to show up for your deposition,
Yeah.
and you're going to have to show up for trial. But he took the added step of saying, guys, I'm not involved in this. I don't have money. This is going to be a hardship for me. I worked on this case for a very short period of time, and I reported some stuff back on what was happening on social media. Now, if he did more than that, he really is this silent killer, and he has these campaigns that are undetectable, even though somebody has apparently detected the campaign. Well, maybe he belongs in this case, but I do have some sympathy for him. I mean, do you agree with that, or do you see?
Yeah, absolutely. He also said that he had some medical issues that was redacted, but the judge will be able to read that. So he had some medical issues that makes it difficult for him to travel. And he said he didn't have an army. He doesn't know how to do
a smear campaign,
an untraceable campaign. He didn't do that. What he did is he monitored everything and he gave reports. If you believe his declaration, it does sound like he got caught up in a whirlwind that, he doesn't really have any business being in, but here he is.
Yeah, it reminds me of people that get caught up in, House inquiries in Congress.
Yeah.
And I forget who it was, but it was somebody during the Reagan administration, and he got beat up really badly in one of the committee hearings. And when he got done with the committee hearing, they asked if he had any questions. He's like, "Where do I go to get my reputation back?" And and it's just
a good question.
It's terrible. Sometimes you get caught up in these things.
Okay. I think this might be pronounced Nick, UK watcher, listener, jury pool. Would this case be something you guys would love to be a part of, i.e. lawyer goals?
Well, we always enjoy a big, juicy case, and this definitely meets that definition. I don't think we would have been qualified to handle this case. We've done a lot of litigation in the past, and we've litigated all kinds of cases, especially when Keith and I first started our law firm. We took anything that would walk in the door. We've done wrongful death jury trials. We've done SH trials. We've done
mass torts,
personal injury. And then we basically became trust and estate lawyers because we enjoyed it, because it was such a complex area of the law. It was like playing chess in litigation. But sure, anybody would, any lawyer would tell you, "Oh no, I don't want anything to do with this very big case that everybody's focused on." If we were qualified, it would be a fantastic case to work on.
Yeah, I think you'd want to be somebody who, regularly practice in New York federal court and, New York law, California law. There's a lot going on here, but yeah, it would have been interesting to be part of it, but not something we would have taken.
Here.
Not that we were asked.
That's you were kind of asked. This might segue well into this question from Crimson Typhoon. How do you both juggle your law firm and then do YouTube? Not complaining. Love you guys.
Well, this morning when I came in, it was 6 a.m. when I got here, and Keith had already been here for half an hour.
Yeah.
And I walked in, and I didn't even have time to get my coffee, and you were already telling me about all the things you'd read about in the Jed Wallace opposition and what you wanted to talk about. So, I mean...
Yeah, we just fit it in. I mean, yeah, both of us are early birds, so I tend to get to the office between 5:30 and 6, and then we have time to work on our other matters as well. And then we also have a lot of help here at the firm who help us out on the other matters. And law is kind of a funny thing because it has peaks and valleys. So there'll be times, and there has been times when we haven't been going live for a string of days because we're just so busy. But then you'll also have some downtime in between that. So it's not a constant with the law practice.
Here, let's end on some of these comments. My English teacher would love you guys.
Oh, awesome. Thank you, JL Max.
And Quarter Fate said, just in time for my rush hour traffic distraction.
Oh, nice.
Thank you. Awesome.
Yeah. And this was a great comment from Jordan. Jury pool, don't forget to give our lawyers a good rating on Spotify. I kind of mentioned that yesterday. Lots of good old episodes on there too. Love the Girardi coverage and your breakdown of the Rachel Sandoval Maddox case. That was a while ago. Remember that, guys?
Yeah. That was
early beginnings.
That kind of hasn't gone anywhere. I haven't seen a whole lot on that.
Yeah.
Right. Well, yeah, I would say that's pretty much it for today, guys.
All right.
Fantastic.
And at the end of the show, we'll be beggars again and say, if anybody is willing to do what, Eric?
So subscribe to the channel, please, everyone. It helps. We're almost at 25,000 subscribers as well. I have a special package in the mail. It's at my house too. And maybe we'll reveal that tomorrow if we go on and do a stream tomorrow. And appreciate everyone liking the video and all the support and comments and questions, as always.
Yeah, and if the Blake Lively, if the Justin Baldoni opposition to Blake Lively's 12B6 comes in as we expect it will this evening, we will probably go in live tomorrow around 2 or 1 or 2. I know you have some appointments tomorrow, but we'll advertise it in advance, and we will do a good job covering that.
Yeah, that'll be a good one. We can't wait to read that one. So that should be tomorrow, probably 2 o'clock or 3 o'clock. And then we can sit down and digest that opposition. That'll be a good one. And we'll see how well they write that one and whether or not they get their form right and the substance. But we really appreciate talking to the jury pool today. Now you know our thoughts on Jed Wallace, and we'll give you the rest on hopefully the lively opposition tomorrow.
All right, we'll see you tomorrow.